Welcome to episode 23 of the Ask the Law Firm Seller Show. My name is Jeremy Poock, and I lead Senior Attorney Match. Today's Ask Show will feature two segments, our Q&A segment and our Poock's Post. So let's jump right into it with our first question today. Our first question today is, what are the options for selling a small business law firm? Great. Thanks for that question. There's really three options, or as we'll explain, really three and a half options for selling a law firm. What we call the preferred option for small business law firms. Those are law firms that are typically run and founded by one or more rainmaker attorneys that have practiced more than 30 years, what we call senior attorneys. And now they're thinking about, how do I sell and to whom do I sell my law firm? The preferred option, as we continue to see in the marketplace, is to sell a small business law firm to a growing law firm, and particularly a growing law firm that practices in similar, what we call like kind practice areas as the senior attorney led firm. Why is that the preferred option? Because a growing law firm that practices in the same practice areas or similar practice areas as a small business law firm run by a senior attorney, they want and need what that senior attorney led firm has, which are clients and referral sources, plus talented lawyers and non-lawyer staff and digital value. And that digital value today really comes in the form of subject matter knowledge that the lawyers in the small business law firm have developed over the course of their careers that growing law firms need today as the source for digital content for multi-channel digital marketing. Second option, and what we call the potential option, is to structure an internal succession plan. The reason why we call that a potential option is because most internal successors are really key employee lawyers. And as key employee lawyers, they don't want to purchase their boss's law firm, and they really can't afford to either. The third option, which we call the risky option, is to maintain the status quo. Status quo really means that there's a hope and expectation and assumption that if today looks like yesterday, then tomorrow will look like today, as will many more tomorrows to come. Well, a very significant disruption began in the legal industry in 2020. As the entire world pivoted digitally, so did the legal industry. And the digital disruption that we continue to see in the legal industry relates to client originations. That is, clients today are bypassing yesteryear's rainmaker attorneys, which by and large are senior attorneys that run today's senior attorney led firms, those small business law firms. And as digital disruption enters the market, particularly Google, as Google continues to become, and in my opinion, has become America's greatest referral source for lawyers, maintaining the status quo means that business originations, that is client originations, continues to be disrupted by today's and tomorrow's clients that search Uncle Google more than they ask their Uncle John or their Aunt Mary for a referral to an attorney. So maintaining that status quo is a risky option for small business law firm owners, because if you're not going to be found by new clients, then your book of business, which is your most valuable asset to your law firm, will diminish in value. And if your book of business diminishes in value, then your law firm is also going to diminish in value. Now let's look, we said before, there's really three and a half options. Let's look at another part of the status quo. Okay, another option, or really part of that status quo option that small business law firms have, if they're not prepared to sell the firm to a growing law firm, or if they do not have key employee lawyers that are interested to purchase their firms, is to consider referring matters to lawyers and other firms for which you can be paid a referral fee per Rule 1.5 of the Professional Rules of Conduct in your state. Too few attorneys really take advantage of Rule 1.5. Many of us are aware of Rule 1.5 in the context of personal injury law, right? That is, someone contacts your firm. If you're not a personal injury law firm, contact your firm, have a personal injury law matter. You contact a PI attorney that you know and that you trust and enter into a referral fee, often a third of what the legal fee is going to be. For lawyers that are maintaining the status quo and are rainmaker attorneys, and that phone continues to ring, the contact forms continue to come in through your website for practice areas outside of what you normally work on, or even within your practice area, let's say, but you don't necessarily want to work on those types of matters at this point in your career. What we recommend as part of status quo is to consider referring those matters to other lawyers whom you trust in consideration for a referral fee. It's important to double check what Rule 1.5 states in your given state. Some states, I sit in Massachusetts, some states don't require any type of dual representation or involvement, otherwise be involved, that is, a referring attorney be involved in the given matter. In all states, as I understand it, the client needs to know that a referral fee is being paid. But if the client knows that the client is going to be in good hands and not pay anything more when a referral is being made to a third party attorney, that is a means to monetize parts of your practice while you're maintaining that status quo. That is by making referrals per Rule 1.5. Now let's look at how does the monetization happen, right? When law firm sales happen, what we're often seeing in the marketplace, really regularly seeing in the marketplace, is what we call law firm sales 1.0. And law firm sales 1.0, the monetization is structured as an earnout. The selling lawyer or selling law firm is being paid a portion of the collected fees from a defined list of clients as well as a defined referral source list. Essentially, that's earnout payments payable over a negotiated period of time. You've developed a book of business. That book of business has value. Any buyer is prepared to pay that value over time based upon the percentage of revenues that come in from that defined, let's call it, book of business. We are also starting to see in the marketplace law firm sales 2.0. Law firm sales 2.0 provides both an earnout, the payment on the book of business, similar to law firm sales 1.0. The additional consideration in law firm sales 2.0 is upfront money paid upon the digital value and brand equity that law firms continue to build in our what we call our 3.0 digital era for the legal industry. We are consistently seeing that law firms that are investing in multi-channel digital marketing, they are attracting the attention of clients that are looking online for their lawyers today, and they're retaining those lawyers in law firms based upon brand equity and digital value of the given firm, not just because it's John Smith at the ABC firm or Diane Jones at the XYZ firm. They are reading about the given firm, the lawyers at those firms, reviewing 5-star Google reviews, reviewing their posts to social media, getting an understanding that this law firm is the type of firm that can meet the interests of the clients. And when a law firm can show data analytics to a buyer, and very importantly, to a bank, that will see that the client origination is not tied to the specific goodwill of a given attorney, but the brand equity and digital value of the law firm that's supported by months and years of ongoing digital brand value and data analytics to support that, then there will be upfront payments based upon the value of that digital and brand equity in addition to the earnout payments paid over time. Okay, so our next question. Our next question today is, what is a key employee Random Tuesday event? Unfortunately, Random Tuesday events happen to small business law firms. And when a Random Tuesday event happens, it causes disruption and it also causes loss in value, short term and long term. The Random Tuesday event that involves a key employee lawyer is when your key employee lawyer, someone who has practiced in your law firm for years, sometimes even decades, walks down the hall to the senior attorney owner and literally gives only a 2 or a 4 week notice that they have accepted a job at another law firm. This has significant negative effects both in the short term and long term. Short term, your key employee lawyer is typically one of the biggest, not necessarily rainmakers for the firm, but the source of revenues that come into the firm. Let's say, for example, your key employee lawyer on an hourly billing type firm is regularly billing 1,000, 1,500, even 2,000 billable hours per year. Well, if that lawyer leaves your firm on only 2 or 4 weeks' notice, your revenues are going to go down significantly in the short term, particularly because it's very difficult to replace any attorney, let alone an experienced attorney in your firm that knows your practice areas and has suddenly just left. And now you're looking for who's going to fill in for those hours. There's also the potential for loss of key clients and referral sources, right? As we know, when lawyers leave law firms, they can provide the clients really with client choice letters. So not only could you lose the key employee in terms of generating revenues for your firm, but the source of those revenues in terms of clients and referral sources, they could walk out the door as well. Longer term, in terms of your goal to sell your law firm, when a key employee lawyer leaves a law firm on a random Tuesday, that could have significant negative effects on two key components of law firm value. One, mentioned before, is loss of clients, right? Your most valuable asset to your law firm is your book of business. And if a key employee lawyer leaves your firm with key clients, all of a sudden your book of business is not worth as much. Secondly, is that when a purchasing firm, if you're considering selling your law firm to a growing law firms, of course, they want your book of business. That's your most valuable asset. But they also need the capacity of lawyers to continue doing the work. Law firms, what we continue to see, typically run at very high capacity. When a senior attorney led firm approaches a growing firm and says, look, we have this book of business filled with clients, we have all types of billable hours available to bill upon, they'll say, okay, well, do you have the lawyers too that continue doing work? Oh, no, we just lost 1, 2, 3 attorneys over the last X number of months. Sometimes we see growing law firms and say, I'm sorry, we just can't help you, right? We'd love to take on those clients, but we don't have the capacity to service that work. So when your key employee lawyer leaves on a random Tuesday, you're also become less valuable to growing law firms because you're not offering as much from a capacity standpoint. Now let's look at why it is that a random Tuesday event even happens. Why does a random Tuesday event happen with regard to your key employee lawyer or lawyers that you know and really assume that they're happy working for you, with you? You hope that they're the ones that are going to take over your practice. The reason why a random Tuesday key employee event can happen is because through the eyes of your key employee lawyers, what is it that they really want? And then we'll talk about what they don't want. But what do they really want? They want a reliable, predictable, and safe job. We call this the RPS meter, actually. Like we're measuring when a key employee lawyer, when their RPS meter, their reliable, predictable, and safe job meter is in the green, then they're going to stay with you. They're going to continue practicing at your law firm. Why and how could that RPS meter move from green to become closer to red is when they actually think that their boss, the senior attorney, could retire, or that their boss has expressed to them that the boss wants to sell their law practice to them. Well, they don't want to purchase your law firm. They can't afford to purchase your law firm. And when their RPS meter, right, is when their job at your firm, at a senior attorney led firm, becomes not reliable, not predictable, and not safe, they can hit up a senior attorney owner of a law firm with 2 or 4 weeks' notice about taking another job. And now let's look at it from a risks versus rewards standpoint. When your key employee lawyer is considering whether to purchase your law firm, what we see is that they really have a risks versus rewards um, um, thought process, really a scale of what are they considering, what are the potential rewards, what are the risks. Of course, the rewards could be that they could increase their compensation, they could enjoy profits, they'll have management authority, they could expand the practice. Then there's the risks. And when it comes to thinking about how to avoid a random Tuesday event with your key employee lawyers, it's very important to understand what are the risks that they're considering as they're considering whether to potentially succeed to your firm or accept a job at another law firm. And those risks include that they're just concerned they may not originate as many clients as their boss had done. That what happens when their boss does retire? How are they going to replace their boss with another attorney? What happens if their revenues actually, that is, the revenues of the firm goes down and they actually could make less money rather than more money by taking over the practice? There are a number of risks involved as key employee lawyers consider succeeding to their boss's law firm. And because those risks outweigh the rewards, that's why we find that your key employee lawyers could instead hit up a senior attorney law firm owner with a random Tuesday event and leave the firm to accept another job. And now let's just look a little bit more about the impact of the loss of a key employee lawyer when they leave a senior attorney led firm. The losses in the short term are that the revenues go down considerably because you're losing a key biller, a key provider of the work in the office. Secondly, and very importantly, is that when key employee lawyers leave the firm, the synergy value of the practice it decreases. That is and if we can just look at the next infographic, is that when key employee lawyers leave your law firm, well, they could leave with clients and also the growing law firms that want to purchase the firm. They want and need your key employee lawyers to continue to service the work. Hence, a random Tuesday event with a key employee lawyer leaving upon only 2 or 4 weeks' notice has short-term impact on revenues, long-term impact on value, and it's just so important for owners of senior attorney-led firms to recognize as early as possible that in all likelihood, your key employee lawyers, they want a reliable, predictable, and safe job. They consider succeeding to your practice as too risky. And if they leave your firm, you're going to lose short-term revenues as well as long-term value as a result. Okay, so for our third question today, our third question is what is the impact on law firm value if a law firm owner suddenly can no longer practice? For example, unfortunately, predecease or become incapacitated. So there are two forms of random Tuesday events that we see that impacts the value of law firms. The first is a random Tuesday event that relates to a key employee lawyer. Second random Tuesday event is the premature death or incapacity of a senior attorney law firm owner. What we see in the marketplace is that the major value of senior attorney led firms is the book of business that a senior attorney or senior attorneys at a firm have developed over the course of their careers. If the senior attorney founder of a firm suddenly can no longer practice because of death or because of incapacity, the ability to monetize the practice, it decreases, it really almost disappears as a result. So let's just look at what happens to client revenues in the event that a senior attorney predeceases or becomes incapacitated. The revenues just plummet. And the reason why they plummet is because typically your senior attorney owner of a law firm is a primary rainmaker of the firm. They are the owner of the firm. They are the ones that are generating significant billables. So when that owner suddenly is no longer available, well, you're not generating as much work and realistically, your key employee lawyers and staff will, in very short order, unfortunately, leave the firm because the firm doesn't have the revenues to support their salaries. They could leave and the revenues just plummet. The second impact is in terms of the how you're going to be able to monetize the practice, because when it comes to the sales of law firms, the sale of a law firm depends upon the earnout that is derived from the book of business of a senior attorney led firm. So, senior attorney who becomes incapacitated or predeceases, yes, the book of business is still there. However, when it comes to how to monetize the book of business, what we call the flux capacitor of law firm sales 1.0, when the monetization of the book of business happens by the sharing in the revenues derived from that book of business, that flux capacitor relies upon trust transfer. That is, that the senior attorney owner of a law firm needs to, and law firm sales 1.0 needs to transfer the trust of their clients to lawyers at a successor law firm. That trust transfer typically happens in person, via Zoom or Teams or Google Meet, or via social media. Unfortunately, if a senior attorney is not available to perform that trust transfer, then the clients are just not going to follow in suit with one or more lawyers at any given firm. They're just going to wind up going to multiple firms, and the family of a senior attorney or the senior attorney, him or herself, if they became incapacitated, will not be able to monetize the law firm because under that law firm sales 1.0, the monetization happens by fee sharing upon the revenues derived from the book of business of a senior attorney. And if a senior attorney, as a result of a random Tuesday event, is not available to transfer the trust of his or her clients to lawyers at a successor firm, unfortunately, the monetization will just become pennies on the dollar. So the message here really, and we can't avoid a random Tuesday event, unfortunately, health issues we just can't predict. But when it comes to senior attorneys that are considering how to sell their law firms, if you're staying within that status quo, that risky option, because you're assuming that tomorrow is going to be like today, that the planning is just so important, particularly for your family that could very well be depending upon the revenues from that book of business that the senior attorney founder of a law firm has worked so hard to develop over the course of his or her career, that if you don't do the planning and sell in advance, set up an internal succession plan, develop a buy-sell agreement, if an attorney becomes incapacitated or predeceases and is not available to transfer the trust of their clients to successor attorneys in consideration for fee sharing over a negotiated number of years, then that fee sharing just will not happen. The monetization realistically will not happen. Okay, so for today's Poock's post. Today's Poock's post is why key employee lawyers consider purchasing their boss's law firm as too risky. So when it comes to selling a law firm, when we meet with senior attorney owners of firms, they're often asking us, all right, what are my options? We explain the options. Preferred option is to sell to a growing law firm. Potential option, structure an internal succession plan. And the third option is maintain your status quo. Most senior attorneys go straight to what? The potential option, right? The potential option. I want to structure a succession plan with my internal key employee lawyers. They know the practice area, they know the clients, and really they deserve to take over this practice and be able to take it to totally different levels. Pay me consideration as the owner over a period of time. The owner, I just want them to succeed and to be able to continue to grow the small business law firm that I've developed over the course of my career. Now we're going to show why, from a risk versus reward standpoint, why it is that most key employee lawyers choose not to purchase their boss's law firm. So when it comes to key employee lawyers, when they consider whether to purchase their boss's law firm, the risks versus the rewards come out, unfortunately, much more in favor of risks versus rewards. And what we see in the marketplace is that from the get-go, and if we could just go back to that last slide, from the get-go, the key employee lawyers, when they start the conversation with their boss about purchasing the law firm, what comes to mind is the rewards, right? That is, if a key employee lawyer is considering succeeding to their boss's law firm, what are those awards, right? They're going to be able to increase their compensation. They're going to have access to profits of the firm, right? They see their boss comes to work every day in a nice car, lives in a nice neighborhood, right? The ability to increase compensation, have access to profits, huge reward. Next is they're going to finally have management authority, right? We can make changes, right? We can improve systems and processes. We can add on to or introduce digital marketing. Let's finally increase our hourly rates. And then let's also think about how we could benefit if we grow the practice. But then what we find is that as an internal successor thinks about the rewards, well, as good attorneys, they're going to think about, all right, what are the issues? What are the risks? And those risks include the following. Certainly, there's a risk of, are the key employee lawyers that would be internal successors, are they going to be able to originate enough new clients to maintain the cash flow at the business? What if they are not the rainmaker type attorneys that their bosses had been for a generation? What if rainmaking in and of itself continues to significantly change in the post 2020 era? We call the 3.0 digital era for the legal industry, where clients are bypassing rainmaker attorneys by and large and searching for lawyers on Google. So if you're not originating enough new clients, cash flow goes down, then we may not have enough money to be able to benefit from those would be those assumed profits. An additional risk is that senior attorney wants to retire, right? But that senior attorney, not only do the senior attorney generate significant amounts of work, they also produce a significant amount of the revenues. They have significant subject matter knowledge and skills. How are we going to find a talented attorney, or sometimes even more than one attorney, to replace a senior attorney founder of the firm? What about exposure to personal guarantees, right? Now you're the owner, right? If an internal employee, an internal successor takes over the practice, well, their name is going to go on that personal guarantee of the line of credit, on the personal guarantee of the lease. What about having to pay the senior attorney consideration for the value of the law firm, even if that's structured, and they typically are, by the way, as earnouts, as fee sharing? Well, that fee sharing over time, that takes away from revenues available for compensation, and for profits. And then what about work-life balance, right? I've always seen senior attorney tell me that he or she was in the office on Sunday, on Saturday, didn't take a 2-week vacation, for years. What happens to the key employee lawyer considering to take over his or her boss's practice? What happens to their work-life balance? And then what about unforeseen risks, right? What happens if a key employee of the firm leaves? How are we going to replace that lawyer or parastaff person? What's going to happen with AI? Right? I mean, like, we have AI, it's exciting, it's interesting, but what if AI causes billable hour rates to actually decrease, for people to retain lawyers less? And then what if personal issues come up? Lots of issues. Like, we're good as lawyers at spotting issues, right? So when it comes to the risks versus the rewards, what we're finding is that even though key employee lawyers initially consider the rewards, often the risks just outweigh those rewards. And as a result, most key employee lawyers, they do not choose to purchase their boss's law firm and decide they really don't want to, and they can't afford to either. So now let's just look at, in terms of, what's the sequence of events that happens when senior attorneys want to sell their law firms generally, and really want to sell their law firms internally to a key employee lawyer. What we find is that senior attorney that makes that announcement to their key employee lawyers that I'm considering retiring when I turn age fill in the blank, or 12 months, 18 months, 24 months from now, or when the lease is going to come to an end. It's not like we're saying that it's going to happen next month. We're giving those internal successors, those would-be internal successors, sufficient notice. Well, what typically happens when the risks outweigh the rewards? Their mindset, that is the key employee lawyers, what they really want is a reliable, predictable, and safe job. When their job is no longer reliable, predictable, and safe because the boss is going to retire, the boss is the one that writes the checks for their salary twice a month, then all of a sudden their job has become more risky, less predictable, and less safe. And there's really two results that can come out of that. The first result is the possibility that key employee lawyers who consider it too risky to succeed as the owner of a law firm, that they will start searching for a new job at another law firm because they just don't want to purchase their boss's practice and they can't afford to either. And when that happens, we call it a random Tuesday event, that the key employee lawyer who a senior attorney wants to succeed to the practice, they only provide 2 or 4 weeks notice. They got what they wanted. That is the key employee lawyers. They restored their reliable, predictable, and safe job meter. They may even take clients with them and referral sources with them. What happens to the senior attorney? First, the senior attorney is pissed off, right? I mean, it hurts, right? When you get really a sucker punch when a person that you've been employing for years and years and years and you want to take over your practice and they leave on only 2 or 4 weeks notice. Now they've got to try to replace the key employee lawyers. They've got to do more work and they have to postpone retirement even more. Well, it doesn't have to happen that way. Let's look at the other choice that that senior attorneys and key employee lawyers have. The other choice is that when senior attorneys, and this is very important, when senior attorney law firm owners recognize that their key employee lawyers do not want to purchase their firms and can't afford to either, but, and it's really not a but, more of an and growing law firms want and need those key employee lawyers to continue to service and provide legal services to the clients of the book of business that a senior attorney led firm has developed, then the entire team can join a growing law firm. And that results in the key employee lawyers getting what they want, which is their reliable, predictable, and safe job. And for the senior attorney to be able to monetize the practice without having to rely upon key employee lawyers to do so when they really don't want to and they can't afford to either. So, in sum, when it comes to the choice for senior attorney led firms, when they're considering to whom to sell their firms, joining a growing law firm presents 4 wins. There are there are 4 winners when senior attorneys sell their law firms to growing firms. The first win is to senior attorneys. Senior attorneys, when they sell their law firms to growing law firms, they're able to monetize the practice. They can spend more time with their families. They don't have to manage the practice any longer, and they can really do what they want to do, which can include continuing to practice, just not needing to practice as the owner of the firm. For key employee lawyers and parastaff, but let's focus on the key employee lawyers. Their win is that they're able to restore, maintain their reliable, predictable, and safe job meter. Whereas it is too risky for key employee lawyers to succeed to owning their boss's law firm in most cases, when the entire team joins a growing law firm together, key employee lawyers are just psyched, right? They're able to work with their team, continue with the senior attorney who's often joining as an of counsel attorney, and they have a deep sigh of relief that they have restored and maintained their reliable, predictable, and safe jobs. The third win is for the clients, right? The clients want to benefit by ongoing, continuing, competent, zealous representation. And when a senior attorney joins a growing law firm with the team of key employee lawyers and key employee parastaff, the clients are relieved because they're able to know that they are in good hands with the team that has been with them for so many years and to benefit by a proverbial deeper bench that a growing law firm provides to the clients. And the fourth win, of course, is the growing law firms, right? What is it that growing law firms want and need? They want and need new clients, which senior attorney led firms offer in terms of their books of business. They very much want and need key employee lawyers and parastaff to have a combined workforce. As growing law firms are growing, they need talented, experienced lawyers and parastaff, which senior attorney led firms offer. And the third item that in today's 3.0 digital era for the legal industry that growing law firms want and need is access to digital value. And senior attorney led firms, they have subject matter knowledge that stems from senior attorneys and key employee lawyers that provides literally treasure chests of digital content that growing law firms need in today's digital era to attract the attention of new clients that are looking online today when considering lawyers and law firms to retain. And that is episode 23 of the Ask the Law Firm Seller Show.